West Palm Beach TV, 30 seconds.
Good morning.
Morning.
I usually get someone says something. I'm the Code Enforcement Special Magistrate for today's hearing. I want to begin by explaining how the process is going to work. We hear the building cases on the agenda first, then the city will call the cases as they appear on the agenda. If you have appeared at today's hearing, your case will be called before the cases where no one has appeared. But that's only true if you've signed in, so if you have not signed in, please check with an officer at the rear of the chamber. Once your case is called, I ask that you come down to the podium on my right-hand side, which is right over there. The city will put on its testimony and evidence first. You'll have the opportunity to review the evidence and ask questions of any of the city's witnesses. You also have the opportunity to testify and present me with your own evidence. Once I have all the testimony and evidence, I will make a ruling. I will enter a written order today at the hearing or in the next few days, which you'll receive a copy of. If you have any questions as we go through the process, please feel free to ask them. This is not a formal courtroom. The formal rules of evidence do not apply here. However, although this is not a formal courtroom, all testimony given today has to be under oath. So if you're going to testify, or you think you might testify, or there's a possibility that you might testify, I'd ask that you rise and raise your right hand so I can swear you in. Do you swear or affirm the testimony you're about to give will be truthful and accurate under penalty of perjury under the laws of the state of Florida? Yes. Please be seated. All right, city can call there first.
Case number 10, CE 250-43491, case address 906 32nd Street.
Good morning. Try that again. Good morning, City of West Palm Beach, Code Enforcement Officer Donald Lattimore. While on patrol, I observed garden vegetation obstructing the sidewalk right away and hazardous tree branches touching the structure at 906 32nd Street. This property is vacant. I initiated my investigation on April 30th, 2025 and observed the following violations. 74-4-C-1, that's hurricane hazard for the trees touching the structure. 744-C4, vegetation obstructing the sidewalk, some leaves and other debris blocking the sidewalk. 74-4C-5, cleaning the property garden waste, leaves that were left in the landscaping. 18-215B for abatement in case the property was not complied. And this is also a repeat violation case. So the case was cited for 26-35-B. And the reference repeat violation case number is CE 230-10193. The city issued a notice of violation to the property owner, which identified the violations, my contact information, and notice of this hearing date. That notice of violation was noticed by certified mail and regular mail on May 1st, 2025 by the city's clerk. I posted the notice of violation at the property and city hall on May 1st, 2025. I also completed the affidavit of posting on May 1st, 2025. I revisited the property on June 5th, June 6th, and June 16th of 2025. During the June 16th, 2025 re-inspection, I observed the property to be in compliance with all violations cited for. So this case is here just basically for the repeat violation. I took the photographs at the initial investigation and when I revisited the property. The following photographs show that the violations are complied on the property, and these photographs accurately and truthfully depict the violations that I observed during my investigation. I have been in contact with the property owner who is currently present, and him and I have been constantly in contact with one another, including walking the property numerous times to address the violations properly. I also want to put on the record that once the property owner received the notice of violation, he lives in an entirely different country. He immediately flew over to address all the violations. So thank you for that. With that being said, the city is asking for a one-time fine of $250, nothing further from the city. For the repeat violation, sorry.
How many days was it out of compliance?
I apologize. What was that, Special Magistrate? I didn't hear you.
Sorry, the new audio system here. How many days was the property out of compliance?
The property was out of compliance starting on June 1st of 2025, and it became in compliant on, it was out of compliance on April 30th of 2025, and it was complied on June 16th of 2025. So we're looking at a total of, I think, 31, 16, 17, 40, roughly 48 days, if I'm not mistaken. I think I did the math wrong.
Okay.
Thank you, Mr. Lattimore. Special Magistrate, the city would like to enter the case file, including the photos and testimony, into evidence, barring any objection.
Sir, can you tell me your name, please?
Marius Ungurano.
I'm sorry, one more time.
Marius Ungurano.
Marius Uberelli?
No, it's Ungureanu.
Ungarelli.
Yes.
Sir, do you have any objections to the documents the city would like to put into evidence?
No.
All right, without objection, I'll accept into evidence the arbitrary case file in this case, the city's composite exhibit. Sir, so the city's telling me that you were out of compliance. They want to do a one-time fine of $250, but they tell me you are otherwise now in compliance. Do you have any objection to that?
No.
Counsel, do you have anything further?
No, sir.
All right, in case CE 250535534, I make the following findings of fact and law. I find notice is sufficient. I find the property having been in violation of the existing code sections. I find that said violation is a repeat violation under the code of the city of West Palm Beach. I issue a one-time fine in the amount of $250. Good luck.
Thank you, sir.
We have case number 8, CE 250-43445, case address 3108 Greenwood Avenue.
Good morning, Donald Lattimore, City of West Palm Beach Code Enforcement Officer. While on patrol, I observed the unpaved parking at property 3108 Greenwood Avenue. This property is vacant. I initiated my investigation on April 16th of 2025 and observed the following violations: 94482A, unpaved parking; 94485E, to pave the driveway. The driveway was not properly paved. 78-6, address characters missing for the home. And 94-302-A-3 to obtain a fence permit. The city issued a notice of violation to the property owner, which identified the violations, my contact information, and notice of this hearing date. That notice of violation was noticed by certified and regular mail on April 18th, 2025 by the city clerk. I posted the notice of violation at the property and City Hall on April 22nd, 2025. I also completed an affidavit of posting on April 22nd of 2025. I revisited the property on June 5th of 2025 and observed the property not to be in compliance with the following code sections: 94-302-A-3, obtaining a fence permit, and 94-485-E to pave the driveway. I took the photos at the initial investigation and when I revisited the property, and these photographs accurately and truthfully depict the violations I observed during my investigation. The property owner is present, and I have been in contact with him numerous times throughout this process. The fence permit is in the process of being issued. There is some issue with the survey that the property owner has to obtain, and he's currently in the process of applying for a permit to pave the driveway. So the owner is requesting an additional 90 days to comply to 2 violations, which will require him to go through the permit process. And the city is also asking for 90 days to comply. If no compliance, daily fine of $100 per day.
Thank you, Mr. Lattimore. Special Magistrate, the city would like to enter the case file, including the photos and testimony into evidence, barring any objection.
Sir, can you tell me your name, please?
Vincent Roselli.
Mr. Roselli, what is your position with the respondent, Greenview Avenue LLC?
I'm the owner.
Mr. Roselli, do you have any objections to the city putting into evidence their documents and testimony?
No objection.
Without objection, I'll accept into evidence the evidence for case file in this case, the city's composite exhibit. Mr. Roselli, the city tells me that you need to surface your parking area and get a fence permit, and then you're in the process of doing that, and that they want to give you 90 days to do that, and that's what you're asking for, is that correct?
Yes, correct. I'm trying to get a updated survey for the lot so that I could complete both permits.
All right, I'll give you the 90 days. Is there anything else you want me to know?
That's it. Thank you.
In case CE 250434445, I make the following findings of fact and law. I find notice is sufficient. Find the property in violation of the listed code sections, specifically parking on an unpaved surface and a missing fence permit. Respondent has 90 days to bring the property into compliance, or a fine of up to $100 per day may issue. Please let the officer know when you're in compliance, okay?
Thank you.
I think that concludes everyone that's present.
To the top.
So, case number 2, CE 250-13166, case address 733 Selkirk Street.
The owner showed up. She be sworn
Is this for case 2?
Yes.
Number 2?
Sorry, yes.
Ma'am, would you raise your right hand? Do you swear or affirm the testimony you're about to give will be truthful and accurate under penalty of perjury and the laws of the state of Florida?
Yes.
Whenever you're ready, Officer Pasmino.
Good morning, City of West Palm Beach Code Enforcement Officer Richard Pasmino. The property at 733 Selkirk Street was inspected in result to a sweep that was requested for the neighborhood, a sweep to check out the properties and cite some of them for maintenance and violations on the block. This case was created on February 18th, 2025. Certified mail was sent out February 18th, 2025. In addition, the property and City Hall were both posted on February 27th, 2025. The violations at the property were found to be 94-442C1, landscaped areas must be grass. The landscaped areas at the property were all white rock without the required grass or natural ground cover. And 94-451D1, artificial turf, that was along the landscaped area as well. I have had constant communication with the owner at the property regarding this violation case, and she has been proactive, trying to work on fixing the violation. Part of that is getting a permit to put in the requested driveway she wants, which will take care of the landscaping issue. As of Monday, the code violation 94-451D for artificial turf has been corrected. So that code is complied. With everything being said, the proactiveness and how much work's going to have to be put into it, she's going to have to, part of the permit application is she needs to get a variance to allow for the amount of vegetation versus driveway configuration. So the city's recommending 120 days to comply this case. If not, we're asking for a fine of $100 a day.
Thank you, sir. And do you believe 120 days is a reasonable amount of time for the property owner to come in compliance for the outstanding violation?
She might need more. I want to hear what she says, just because the variance process is a very long process in hearing approval.
Understood. Thank you, sir. Special Magistrate, the city would like to enter the case file, including the photos and testimony into evidence, barring any objection.
Ma'am, can you tell me your name, please?
Jennifer Lynn Beck Rodriguez.
Ms. Rodriguez, do you have any objections to the documents and testimony the city would like to put in evidence?
No.
All right, without objection, I'll accept in evidence the arbitrary case file in this case, the city's composite exhibit. So the city says that you need more grass on your area, and they want to give you 128 days to come into compliance. Is that your understanding as well, ma'am?
Yeah, I need to have more time if possible. I'm actually working closely with the Commissioner's Office, Christina Lambert, as well, regarding the code itself. It's kind of outdated. It's not suitable for everyone. Not to mention that, as I've already spoken in depth with Richard, it's that unfortunately I was targeted, if you will, because of the neighboring persons that were not complying, with the city. And so, but in my vicinity itself, there is a very long list of a lot of homeowners that have the same look as my home. It's cleaner, it's neater. Overall, it's just much better. If we look around, I know that the city is requiring all this grass that owners cannot keep up with. Essentially, the water is very expensive in that area, and no one has green grass. Everyone has weeds. I actually just implanted those that grass where the artificial turf is, and I'll keep up with it. But are the neighbors going to keep up with it? They don't. So, I mean.
Yeah, ma'am, I'll be honest. Everything you were saying may well be right. It's just beyond my. I don't write the code, so.
No, I understand. I'm not saying that we need to rewrite the code. I've been in contact with.
Maybe the city does, but ultimately, I'm not the. The
No.
city council.
When it comes to what you can do in my case would be allow more time for me to go ahead and continue working on
The
this.
city's offered 120 days. Is that a sufficient amount of time for you?
Probably not, but we can come back and figure it out at 120
How
days.
much time do you need?
It depends on how much time the city needs to enforce the surrounding neighbors on and getting cited. Christina Lambert also stated that the code enforcement should be working on that as well, so that I'm essentially not the only one vouching for the situation. Because if all those different houses, which is I think it's well over 50 homes, just in that block, in that vicinity, then we'd all be here stating the same thing, that code is outdated. The fact that the city wants all this grass is completely just not doable. I mean, just alone myself and my household.
The city council is the right person to go for that. I can give you time, but you have to make an ask. I can't just pull a number out.
Time?
Yeah, how much time do you need?
Well, I mean, Richard,
Yeah. So
how much time does the city need to cite everyone around?
that's not going to resolve your case.
No, I know it's
Yeah.
not going to resolve it, but I mean, essentially, Christina Lambert is
Yeah,
needing.
I can't give you time to cite other people. The question is how long to bring your property into compliance.
Well, we can do 6 months, and then we can come back at that time.
Officer Pazmino, what does the city feel about 180 days?
I have no objection to that.
Done. All right, case CE 250-13166. I make the following finding of fact in law. I find notice is sufficient. I find the property in violation of 94442C1, which is that the landscaped areas must be grass. I'll give them 180 days to bring the property in compliance, or a fine of up to $100 per day may issue. Good luck. I hope you're able to get your changes.
Thank you.
I understand we have someone else here for case number 3. Justin Duran? No? He left? Okay. Oh, well. It's the next case anyway.
It's the next case either way.
I just didn't know if he was sworn in or not.
Oh, no, he came after, but he didn't stay.
Okay, well.
Okay.
Case
Good
number
morning.
3 of the agenda, case number CE 250-53572, case address 915 36th Street.
Good morning, Code Officer K.T. Weaver with the City of West Palm Beach. While checking and complaining in the area, I observed several violations at 915 36th Street. I took photos of the property which accurately and truthfully depict the violations observed. I initiated my investigation on May 19th of 2025, citing the following violations. Property was cited for 74-34-A-1-H, trash can in public view, which has been complied. 78-6-1, address numbering size, which has been complied. 94-451-D, artificial turf, which has been complied. 94-71-C, outdoor storage, which has been complied. 18106-A, clean and sanitary for the pressure washing. 78-94-C, swells and parkways. 94-442-C-1, landscape areas must be grass. The notice of violation was posted at the property and City Hall on May the 20th of 2025. The affidavit of posting was completed on May the 20th of 2025, and a copy was placed in the case file. Certified and regular mail was sent to the mailing address listed on PAPA on May the 23rd of 2025. The certified mail was returned. I revisited the property on June the 17th of 2025 and observed the property still in violation of the following violations: 18-106-A, 78-94-C, and 94-442-C-1. Pre-inspection photos were taken showing the remaining violations. They were uploaded to the case file. I have spoken with the property. Originally, it was the property owner's mom. This morning, the property owner himself came in and just spoke with him, but he did not want to stay. But they are requesting an additional 60 days to gain compliance. The city is also requesting an additional 60 days to gain compliance, or $100 a day until compliance is achieved.
Thank you so much. Special Magistrate, the city would like to enter the case file, including the photos and testimony, into evidence, barring any objection.
Well, since there's no one here to object, I'll accept in evidence the evidentiary case file. In this case, the city's composite exhibit. Is 60 days a reasonable amount of time to bring this into compliance?
Yes, sir.
All right. In case CE 2505357-2, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 7894C. Swells and parkways have to be sodded and seeded properly. 18106A, clean and sanitary, and there needs to be pressure washing. And 94442C1, the landscape area must be grass. Respondent has 60 days to bring the property in compliance, or a fine of $100 per day may issue.
Thank you.
Case number 4, CE 250-43462, case address 1650 45th Street.
Good morning, Officer Forstier, West Palm Beach Code Compliance. This property was cited on 4/23/25. Certified mail was sent on 4/29/25. Certified mail was returned at 5/6/25. Both the property and City Hall were posted on 6/6/25. I have not been in contact with the owner. The property was cited for 18-106-A, clean and sanitary conditions, trash and debris on the property. 18-106-B, excessive growth of grass and weeds. 18-106-K, landscape shall be maintained. And 94-442-C-1, there's missing sod and grass throughout the property. The city is asking for an additional 15 days for compliance and $100 a day after compliance is not achieved.
How many days?
15.
Good morning, sir. Did you take the photos that we've seen here today? Did you take these photos yourself?
I did.
And do these photos accurately depict the code violations that you cited today?
Correct.
And do you believe 15 days is a reasonable amount of time for the property owner to come into compliance?
Yes.
Thank you. Special Magistrate, the city would like to enter the case file, including photos and testimony, into evidence.
Without objection, I'll accept in evidence the evidentiary case file. In this case, the city's composite exhibit. Have you had contact with the owner here?
No contact. I've been ignored.
Sorry?
I've been ignored. I've tried several times.
Somebody living at this home? As best you
There
can tell?
is.
So basically, they have to, it looks like they have to sod the yard here.
Mhm.
What's the landscape maintenance? Is that just the condition of the yard?
Yeah, the neat and clean.
What's the excessive growth?
The excessive growth is on the side of the house, alongside a fence, and around the bushes in the front.
And the clean and sanitary is just the
Right,
garbage
yeah.
that's
Right
screwed there?
the other road. Say again?
Yeah, okay, yeah. This looks like a pretty big job, so I'm going to give him 30 days. What were you seeking, $50 a day?
$100 a day.
$100 a day? All right, in case CE 250434662, I make the following findings of fact and law. I find notice is sufficient. I found the property in violation of the listed code sections, specifically 94442C1. The area must be landscaped. 18106K, the front, side, and rear yard have to be maintained. 18106B, excessive growth. There are plants there that are overgrown. And 18106A, clean and sanitary. The trash and debris must be picked up. I'll give the respondent 30 days to come into compliance, or a fine of $100 per day may issue.
Thank you.
Case number 5C, E 25053568, case address 428 Avon Road has been rescheduled. Case number 6, CE 2504353, case address 3316 Greenwood Avenue.
Welcome back, Officer Latimer.
Thank you.
Anytime you're ready.
Perfect.
Good morning, yes, thank you.
All right. Good morning, Donald Lattimore, City of West Palm Beach Code Enforcement Officer. While on patrol, I saw a resident construction site not being properly maintained. The site address was identified as 3316 Greenwood Avenue. This property is vacant. I initiated my investigation on August 21st. Please note that this initial investigation for this property started out as a courtesy notice. I gave them a courtesy notice. But on 4/21/2025, I observed the following violations. 94-316-D-A, maintaining the construction site. As I mentioned, it started out as a courtesy case, and on 5/19/2025, due to no attempts to address the courtesy notice that I gave to them, the case was upgraded to a hard case, which would include this special magistrate hearing date. At that time frame, the additional code violation 94-316-D-2-C-2 was also added to the case due to a temporary construction fence for chronic nuisance and safety hazard. Public safety was needed. So on 5/19/2025, the city issued a notice of violation to the property owner, which identified my contact information and this hearing date. The notice of violation was certified by regular mail and certified mail on April 20th, 2025 by the city clerk, and I posted the notice of violation at the property and city hall on April 25th, let me go back. The notice of violation was noticed by certified mail and regular mail on May 20th of 2025 by the city clerk. And I posted the notice of violation at the property and city hall on May 21st, 2025. I also completed an affidavit of posting on May 21st, 2025. I revisited the property on June 9th of 2025, as well as June 13th of 2025, and observed the property not to be in compliance with the two violations that the property was cited for: maintaining the construction site and adding a temporary construction fence. I took the photographs at the initial investigation, and when I revisited the property, these photographs show that the violations still exist on the property. The property owner is not present, and I have not made contact with the owner or a representative. I did make contact with an electrician on May 23rd of 2025 at the property. Per the electrician, he told me that he will inform the construction site manager to contact me, and I left all the information necessary for the electrician to have the construction site manager to contact me, but no one ever contacted me. Given the current chronic nuisance, the condition of this construction site, and the safety that it's causing in the area, particularly with the sidewalk and the right-of-way, The city is asking for 14 days to comply, and if no compliance, a daily fine of $100 per day.
Nothing further at this time, Special Magistrate. We're asking for the code enforcement officer's testimony, the photographs taken, and the case file to be admitted into the record as evidence, please.
Without objection, I'll accept those documents and evidence as city's composite exhibit. Is 14 days a reasonable time for them to bring this into compliance?
I spoke to the permit supervisor and I informed them about the temporary fence. I was informed that a temporary fence should have been applied for prior to starting the construction work. And he did, in fact, tell me that 14 days was generous time. I actually recommended 10 days. So, yes, it's a reasonable amount of time.
All right, fair enough. In case CE 250434453, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 9436316D2CT, the missing construction fence for the construction going on the property, and 94316D1, which is the job site maintenance, which is the activities are not being maintained properly, including blocking the right-of-way on the sidewalk. Respondent has 14 days to bring the property in compliance, or a fine of $100 per day may issue.
Case number 7, CE 250-53534, case address 906 33rd Street.
And Donald Lattimore, City of West Palm Beach Code Enforcement Officer. While on patrol, I noticed the front landscape at 906 33rd Street missing sod. This property is occupied. I initiated my investigation on May 16th, 2025, and observed the property observed the property to be in violation of the following: 94-442-C-1 to sod the landscape, 22-441 to renew the rental license, 22-32-A to renew the certificate of use for the property. The city issued a notice of violation to the property owner, which identified the violations, my contact information, and notice of this hearing date. That notice of violation was noticed by certified and regular mail on May 16th, 2025 by the city's clerk. I posted the notice of violation at the property and City Hall on May 16th, 2025. I also completed an affidavit of posting on May 16th, 2025. I revisited the property on June 16th, 2025, and observed the property not to be in compliance with all of the code sections. So still not in compliance. I took the photographs at the initial investigation, and when I revisited the property, the photographs show that the violations still exist on the property, and they accurately and truthfully depict the violations I observed during my investigation. The property owner is not present, but I have made contact with the property owner, Rebecca. I'm familiar with her situation. She's facing some family health issues. Rebecca is requesting an additional 60 days to comply all of the violations, especially the front landscaping. So we had a really good discussion about what she needs to do. With that being said, the city is also asking for 60 days to comply all violations, and if no compliance, a daily fine of $75 per day.
Counsel?
Oh, I'm sorry, Judge, I was waiting for, nothing further at this time. We're asking for the code enforcement officer's testimony, the case file, and the photographs be taken into the record as evidence, please.
Without objection, I'll accept in evidence the testimony, evidence, and documents as city's composite exhibit. Guess I don't really need to ask you if 60 days is reasonable. That seems more than reasonable in this case. All right, in case CE 250-53534, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 22441, business license 2232A, certificate of use, and 94442C1, the landscaped areas have to be grass. Responded to 60 days to bring the property in compliance, or a fine of $75 per day may issue.
Case number 9, CE 250-53605, case address
3415 Windsor Avenue.
Donald Lattimore, City of West Palm Beach Code Enforcement Officer. While on routine patrol, I noticed a vehicle parked on the grass at 3415 Windsor Avenue. This property is occupied. I initiated my investigation on May 19th, 2025, and observed the following violations: 18-106K and 94-482A. The city issued a notice of violation to the property owner, which identified the violations, my contact information, and notice of this hearing date. That notice of violation was noticed by certified and regular mail on May 30th, 2025 by the city's clerk. I posted the notice of violation at the property and City Hall on June 4th of 2025. I also completed an affidavit of posting on June 4th of 2025. I revisited the property on June 16th of 2025 and observed the property not to be in compliance with the following code section: 18106K. That's the landscape maintenance. Basically, the owner has planted some seeds down to grow the grass. He's trying to wait to see if a few more areas will grow in, but the grass is starting to get high, so he will have to cut it eventually. So he's asking for additional time to just wait to see if some of the seeds will continue to pick up and cut the grass. The property owner is not present, but I have been in constant contact with the property owner throughout this investigation. All of the violations were explained, how to comply them, including this special magistrate hearing date. I also discussed with the property owner a finding of fact will be asked for during this hearing for the unpaved parking. They're constantly parking on the grass. And I also explained that future cases related to unpaved parking may result in a repeat case. So very well aware of what's coming down the future. For code, with that being said, for code violation 94-482-A, which is the unpaved parking, the city is asking for a finding of fact. The previous case, if needed, that shows and illustrate the previous parking is CE 241-23049. That previous case was opened on December 10th of 2024, and it was closed March 4th of 2025. So pretty recent with the unpaved parking. For code violation 18-106-K, the city is requesting an additional 30 days to comply. If no compliance, a $50 per day fine.
How many days?
30. 30, thank you.
And you believe that's a reasonable amount of time, the 30 days?
Yeah, about 2 more weeks to see if some grass to grow. If not, cut the grass.
Especially with the rain.
Yes, exactly.
Hopefully.
Yes, so reasonable time, yes.
Nothing further, Special Magistrate. We're asking for the Code Enforcement Officer's testimony, the case file, and the photographs shown to be accepted into the record as evidence, please.
So admitted. So you want 30 days or $100?
30 days or $50.
$50. I guess it looks like they put up no parking signs, huh?
He's I like working with him. He's trying his best.
Okay.
So he understands.
All right, in CE 25053605, I make the following findings of fact and life. I notice is sufficient. I find the property, having been in violation of 94482A, has since come into compliance after the required compliance date, and in violation of 18106K, which is the landscape maintenance. Respondent will have 30 days to bring the property in compliance or fine of $50 per day may issue.
Case number 11, CE 250-53521, case address 1006 26th Street.
All right, Donald Lattimore, City of West Palm Beach Code Enforcement Officer. While on patrol, I observed a business operating at 1006 26th Street without a business license. This property is occupied. I initiated my investigation on April 28th of 2025 and observed the following violations: 82-144, no business license; 22-441, no rental license; and 22-32-A, no certificate of use on file. The city issued a notice of violation to the property owner, which identified the violations, my contact information, as well as notice of this hearing date. The notice of violation was noticed by certified and regular mail on May 8th, 2025 by the city's clerk, and I posted the notice of violation at the property and city hall on May 21st of 2025. I also completed an affidavit of posting on May 21st, 2025. I revisited the property on June 12th, 2025, and observed the property not to be in compliance with the following code sections. 82-144, still no business license, and 22-32-A, no certificate of use. I took the photographs at the initial investigation and when I revisited the property. The photographs show that the violations still exist on the property, and these photographs accurately and truthfully depict the violations I observed during my investigation. The property owner is not present, but I made contact with the property owner on June 9th, 2025, explained all the violations to the property owner, and he immediately obtained a rental license. I also made contact with the business owner on May 21st as well as May 28th and explained to him as well the violations and how to comply them, which they are making significant strides towards complying the violations that are remaining to obtain that business license and certificate of use. With that being said, the city is asking for 30 additional days to comply. If no compliance, a daily fine of $100 per day.
Thank you, and 30 days is a reasonable amount of time?
Yes.
Okay, nothing further, Special Magistrate. We're asking for the code enforcement officer's testimony, the case file, the photographs to be admitted into the record as evidence, please.
Without objection, so admitted. So they got the rental license, but they didn't get the business tax receipt and certificate of use for the business that's operating on the property?
Yes, that is correct. They had to apply through SunBiz, and it was a little hiccup with SunBiz that slowed them down, but now they are officially licensed with the state of Florida, and they're just making their way down to obtain that license through the city of West Palm Beach.
Sounds like they're well on their way. In case CE 2505351, I make the following findings of fact and law. I find notice is sufficient. Find the property in violation of 2232A and 82144 with the business tax receipt and certificate of use need to be obtained for the business operating on the property. Respondent has 30 days to come into compliance or fine of $100 per day may issue.
Case number 12, CE 250-53550, case address 2620 North Australian Avenue has been complied. Case number CE 250-53547, case address 2650 North Australian Avenue has been complied. Case number 14, CE 250-53543, case address 2620 North Australian Avenue.
Don Williams, Code Enforcement. I cited the business Community Counseling and Services located at 2620 North Australian Avenue on May 14, 2025 for business tax receipt, code section 82-144. The previous license they had expired September 30th of last year. Certified mail and regular mail sent out May 14th of 2025. City Hall and the property was posted May 15th of 25. No contact with the owner of the business. However, the building manager did verify that the business still operates from that location and still has failed to obtain a business tax receipt. My recommendation is a 10 days to comply or a one-time fine of $100.
Thank you, and 10 days is a reasonable time?
Yes.
And you stated you spoke with the business owner?
No, the property manager.
The property manager?
Her name is Shalandra Stringer.
Okay, thank you. Nothing further, Special Magistrate. We're asking for the code enforcement officer's testimony and the case file to be admitted into the record as evidence, please.
Without objection, so admitted. Sounds like that business location kept you busy, huh?
Yeah, it did. But 4 of them complied yesterday.
The nick of time.
Yeah, right.
As always.
Is this a renewal or is this a first-time business?
Renewal.
It's a renewal.
Yes, renewal.
Okay. So 10 days seems more than reasonable to me.
Yes.
In case CE 250-53543, I make the following Findings of fact in law, I find notice is sufficient. I find the property in violation of 82-144. The absence of the renewal of the business tax receipt. Respondent has 10 days to come to compliance or one-time fine of $100.
Case number 15, 2620 North Australian Avenue. I'm sorry, case number CE 250-53541.
Don Williams again, Code Enforcement, City of West Palm. I cited this business Legacy Pillars LLC for a business tax receipt. Cited the business May 14th of 2025 for Code Section 82-144. Previous license expired September 30th of 24. Certified mail and regular mail sent out May 14th of 24. City Hall and the property posted May 15th of 25. The certified mail and regular mail was sent out May 14th of 25. And City Hall and property posted May 15th of 25. No contact with the business owner. However, contact made with the property manager, Ms. Shalandra Stringer. She did verify the business still operates from that location. So my recommendation is 10 days and one-time fine of $100.
Nothing further, Special Magistrate. We're asking for the code enforcement officer's testimony to be accepted into the record, as well as the case file, please, as evidence.
The objection so admitted into evidence. The business is Legacy Pillars.
Yes.
And the area manager confirmed that they're still in operation?
Yes, sir.
Okay. And this is a renewal as well?
Yes, sir.
All right, in CE 250-53541, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 18-144, failure to obtain the renewal of their business tax receipt. Respondent has 10 days to come into compliance or one-time fine of $100.
Thank you.
Case number 16, CE 250-53551, case address 2620 North Australian Avenue, has been complied. Case number 17, CE 250-53545, case address 2620 North Australian Avenue, has been complied. And that's the last case for the agenda.
Are we still scheduled at 11:30?
Correct.
All right, so we're going to be in recess until 11:30.
Thank you. Call. How do we, pages or cases? Oh, I thought he said pages.
Everyone signed in?
West Palm Beach TV, 30 seconds.
All right, I hereby call us back into order. This is the special magistrate hearing for the City of West Palm Beach. Cases are going to be heard in the order in which they appear on the agenda. When you hear your case called, go ahead and proceed to the podium on my right-hand side. The city will introduce the case, then you'll have the opportunity to ask me for whatever remedy that you're seeking in this case. In most cases in the special magistrate other matters agenda, most of these tend to be reduction of fines. So in particular, what you need to tell me is what specifically you're asking me to do and to give me the justification or reason why I should do that. Please note that I am bound by the code of the City of West Palm Beach, which means that I can only consider those elements and things which are permitted under the code. So hopefully you've had an opportunity to review justifications that are permitted under the code and can ask me for something that I am permitted to do. With all of that said, we can call it, oh wait, anyone that's going to testify today or thinks they're going to testify, there's a possibility that they might testify. I'm going to ask that you rise and raise your right hand so that you can be sworn in. Anyone that's going to talk or might talk? Do you swear or affirm the testimony you're about to give will be truthful and accurate under penalty of perjury under the laws of the state of Florida? All right, please be seated. City can call the first case.
Case number 18, CE 230-80463, case address 628 41st Street.
John Frosca, West Palm Beach Code. For this particular case, Notice of service was effectuated by certified mail and regular mail on August 17th of 2023. The certified mail was signed for on August 21st of 2023. The property was also posted in City Hall on September 5th of 2023. The special magistrates administered an order on September 20th of 2023 for 14 days to comply by October 4th of 2023, or $100 day fine until compliance is achieved. The order imposing fines started from October 5th of 2023, and the date of compliance was March 1st of 2025, leaving a total number of days out of compliance, 533 days, for a fine amount that is totaled $53,300. The type of violations that we had were for excessive grass height, 74.4C3, maintaining the swales, 78.94C, and unpaved parking in the front of the property. The other violation was struck, the outside storage. I did have a conversation with the owner of the owner's daughter of the property, and she was in agreement that we would settle it for $3,700.
Ma'am, can you tell me your name, please?
My name is Tiffany Vasta.
And Lucio Vasta is your mother?
Lucio is my father.
Father.
Yeah.
And they know that you're here on behalf of them?
Yes, he lives in New York.
Well, it would be a heck of a drive, right?
Yeah.
The city says that you're in agreement to accept a fine of $3,700? Is
Yes.
that correct? Did we have a time frame on that?
I would refer to I think it should be paid immediately, but I would refer to the representative.
We do have it under contract, trying to sell it right now. So, I mean, we could definitely have the money by next month, but if needed, I could probably get it sooner.
About 30 days.
Okay, that would be fine.
City's good with that.
Yeah.
All right, in case CE 230804663, based upon the agreement of the parties, the fine is reduced to $3,700 payable within 30 days. If it's not paid in that time, it returns to the original amount. Thank you for coming in, ma'am.
Ma'am? Case number 19, CE 19060-120, case address 3209 North Australian Avenue.
Be careful.
Did we agree upon that amount? Okay, we'll hear it. Okay. 218 Westminster, case CE 06. Thank you.
3209
I'm
North
out of
Australia.
order. 32.
Yeah.
Thank you. Sorry. Sorry, Mr. Tate. All right, 3209 North Australian Ave, case CE 19060120. Notice of service was effectuated by certified and regular mail on June 10th, 2019. Certified mail was received on June 13th of 2019. The property was also posted, and City Hall was posted on June 18th of 2019. The date the special magistrate administered the order was July 17th of 2019 for 30 days to comply up to August 16th of 2019, or $100 a day till compliance is achieved. The order imposing lien started from August 19th of 2019, and the date of compliance was April 1st of 2020, for a total number of days out of compliance, 226 days, with a fine amount of $22,600. The fines, the violations were exterior windows and doors repair, exterior paint required, and landscaping of the public right-of-way. I did review all of the case file and the documents, and they were accurate, that he did need to paint, that there was a broken window, and the siding of the parkway and or the swale in the front of the house.
Okay, sir, can you tell me your name, please?
Yes, Corey Tate.
And Mr. Tate, you're the owner of the property?
Yes, sir.
All right, what are you asking me for, and why should I grant it to you, sir?
The reason why I'm asking for the reduction is, and I feel you should grant it. I'm not denying there was the first two, the paint and and I think there was something else. But as far as the swell, when I purchased the house, it had rocks in the swell because I'm on a major artery. I'm on Australian Avenue. So a lot of cars pull over. The rocks were there prior to me purchasing the property. So when they came in, they said, okay, you did the paint and you did the other item. They said, now I got to put grass down as well. I said, there's nothing wrong with the rocks. They've been there for years. And they said, no, you got to put grass down. So I had to come out and
Sir, just to stop you, whether that's true or not, it's beyond the scope of the authority of this particular hearing. I can't relitigate the finding that you were in violation.
No, okay, I agree with that. But the point I was trying to get to is that once I went and I paid for the grass to get replaced, and I called code enforcement back out to say everything was done. Everything was done, but she said she can't close the case because the crash cans were left out. That's something totally different. They were left out there overnight. I said, that's something totally different. The other three items are corrected. And that's why it stayed open so long, because I didn't know at the time that it was staying open that long. So I don't mind.
Are you telling me this ran 226 days because you left your trash cans out?
That's basically what exactly I'm saying, yeah. Because it never got closed. Until it's closed, the days keep going on. And I didn't think it was going to go that late. That's why I didn't find out till that year after. If you look at the date, almost a year later, that was, oh my God, this is racking up. And now I'm coming to it. That happened in 2019. Here it is, 25. I'm just trying to get it corrected.
So what are you asking me for?
If I could pay, I know the city offered a fine of like 22 or 27. If I can get that down to $1,000, that'll help me out a lot considering my situation.
The city recommended $2,600 at a 10% reduction based on the gravity of the violation. It wasn't about trash cans, it was about window repair, it was about painting the exterior and landscaping the swale. And I did review the pictures and from the before and the after, and he did a beautiful job taking care of that. But what we wrestle with is the 226 days out of compliance. And so based on all of those facts and the condition the property's in now, that the city said, okay, well, $2,600 is a fair amount and you could pay it over a 6-month period if that would be agreeable, but I think that's reasonable.
I gotta be honest, Mr. Tate, I think the city's offer is pretty generous. 10%, 6 months to pay, it's a pretty good deal. I mean, unless you can give me something else, that's my inclination. I'll be really honest with you, Mr. Tate, since we're all sitting here anyway, I probably wouldn't have gone down that far.
Okay.
All right, in case CE 19060-120, I'll reduce the fine from $22,600 to $2,600 payable 6 months. Which is what, 180 days? Thank you for coming in, sir.
Thank you.
Sir, here you go. So when you, this way you can go pay.
My agenda.
To get the fines. You're welcome. Case number 20, CE 160300291, case address 218 Westminster Road.
You can wait until we call the case and then present it. Okay, no, you have to stand up there, and if you're going to testify too, I would. Okay, 218 Westminster Road, case CE 16030291. This is a building case. Notice of service was effectuated by a red tag posting on March 1st of 2016. Certified mail was sent October 4th of 2016. Certified mail was received on and signed October 11th of 2016. The special magistrate's order was administered on December 7th of 2016 for 30 days to comply, or by January 9th of 2016, or a $100 a day fine will run until compliance is achieved. The order imposing the lien was January 10th of 2016. For the date of compliance would be December 24th of 2019, leaving a number of days outstanding, 1,078 days, for a total fine amount of $107,800 for failure to secure a building permit. And doing the background on this, it was for a dance studio, and alterations were made inside of the house. And that's what the violation consisted of construction. It says here, structural improvements for the residence or business, or improvements of the structure and assembly, which they're referring to the wall, and the electrical within the wall. And that's what the violation was for originally. The city did make an offer of 10%, which would be $10,780, which really boils down to like $10 a day, but they wouldn't have it.
Sir, can you tell me your name, please?
Michael Carey. It's my wife, Lisa Carey. Can I give you the dates these occurrences happened to
You can show it to the code officer first and the city attorney.
become part of the record, sir?
I can, if they don't object, but hold on one sec.
All right, let me answer then. So conversion to a dance studio, there was never any conversion made in the house for a dance studio.
As I told the other gentleman, I can't relitigate.
Okay, well, I
the
just want to put this on the record. So
Whoever the special magistrate was that made the decision, they made a decision.
In 20, can I
Yeah, well, I just want to be clear. That decision is appealable at the time, but at this point, I can't go and open up and decide whether or not that magistrate made a right decision.
Okay, I just want to state my case and make my proposal, okay? So in 2015, we licensed my daughter, who's a teacher at Dreyfus, got a license to give lessons in the living room. There was never any modification to our living room or our house for a dance studio.
Again, I can't relitigate the case.
I understand that. And then when my neighbor, who's upset that little kids were coming and going, little children were coming and going from the house, called the code enforcement. They came down. I was making a repair for water damage inside the vestibule of my house. It was already completed at the time the violation was made. I got a building permit. I paid for the building permit. I have the receipt here. I paid for the building permit in January of 17. And
Mr. Carey, I feel like you want to tell me that the citation was issued improperly and that you shouldn't have been found in violation. Whether that's true or not, I can't hear that. It's not relevant to my case.
okay. So I'm telling you why I'm making my proposal. So
I got it. You feel like it was issued in error.
it wasn't issued in error. We did get a building permit. I paid for it, and all the departments stamped the permit by January 30th of 2017. Okay, the permit was issued at that date. I paid the double fine. I have the receipt for the double fine. All right, we didn't pick up the permit, and it wasn't final. That's different than the permit being issued. The work had already been completed. In fact, in the request for the permit, there are pictures of the completed work, which was acceptable. So that's what happened, all right? Then when I came in 19 for another issue, they said there's an open permit. It never got picked up. They said, oh, that's 2 years. Okay, that's where we are. John has been very helpful, offered 10%, which is $10,000. We've been in the house 40 years. I'm retiring this year. That's a huge amount of money for me. The permit, the double fee permit costs $255. I'm proposing I pay 10 times the permit amount, $2,550, and I could pay it today. If they could find that acceptable, it'd be very helpful.
What's the city's position on that offer?
Can I ask a question? Because it's contract work and it's contract required, you know, a licensed contractor.
No, it wasn't. It wasn't. It was, I pulled
You
it
did it, but you did an owner builder then?
Yeah, and
Okay.
I had a estimate from a professional contractor, and and the first part of it was $1,100 inside the vestibule, and the outside corner of the house in the back was, I think, $1,200. I have that written estimate here. Kennedy was the building guy. He told me, you may not need a permit, go get a professional estimate. So I did that. I should have not done it, but.
Well,
Anyway,
you know,
it
based
came
on-
out to $2,600 or so, the total permit amount.
Okay.
I mean the work amount, the amount of the work.
Based on that, and I did have a conversation with the assistant building official and one of the building inspectors, and the seriousness of the violation, because I asked him how serious was it, and he said not so serious. So I said, oh, that was his response. So I said, okay. I think the best position for the city would be the lowest will go is $3,000, and that's it. I mean, I think that it would be fair based on all the circumstances.
I appreciate that, and I'd take that.
And how many days to pay?
30 days to pay?
Very good.
All right, CE 1603021, I reduced the fine to $3,000 payable 30 days.
Thank you for your help.
There you go.
Have a good day. You're welcome. Case number 21. This gentleman has 3 cases. Your Magistrate, you want to hear them together?
Are they the same property?
Yes, sir.
423. Yep, let's hear them all.
Okay.
Great.
So let's start with the first one, case number 21, CE 201-00163, case address 423 48th Street.
Before we start with the service, this is a rehear. It's a bite of the second, you know, it's a second bite of the apple, because they already did go for a settlement before. So, to start with that case, CE, it was.
Did it go to hearing in front
it
of
did.
a magistrate?
Yes, it did.
Was it me?
Yeah.
Was it, might not have been
I
me?
don't know if I have that information, which magistrate it went to.
It was you.
It was me?
Yes, sir.
Okay.
Okay.
All right, do we want to, why don't we call the other 2 cases, so we'll hear them all at once, so. Do you want to go
You
ahead and
wanna
call?
call them together?
Yeah.
Sure, no problem. That would be case 23, CE 070-40338, same case address, 423 48th Street. Case number 24, CE 060-40590, case address 423 48th Street.
So tell me, why are we back again? What happened the last time?
It was not paid within the time frame that it should have.
Ah,
So
there
it
was,
reverted back to the original fine amount.
and what was the original order that lowered it?
It was a group, 3,000 for each property.
If I may, Special Magistrate, is the city's position right now to go back to the original reduction, the lien reduced amount of $3,000 per property?
Yes.
Per case, same
Right,
property.
right, per
Yeah.
case. We left it the same. And when I looked it over and I did the numbers and I figured it out, it would justify that amount based on what the city has been requiring. So, and I think that's a very fair, the city's very fair about that.
Well, the city would not want to reduce, given the fact that we already
Right.
gave a reduction.
Yes.
It was ordered to be complied with within a year, I'm assuming, and it wasn't complied. I don't, I mean,
it wasn't paid.
it wasn't paid,
Right.
correct. So.
No,
don't-
I think that that's a generous move on the city's behalf to return to the original settlement, but let me hear from
Correct.
the respondent.
John Cleary on behalf of Michael Cleary. Your Honor, I am his cousin. I agree, it is generous. There's only one problem. He works at a hardware store where he's worked there. He's lived in that house. That's his homestead. He's broke. And the reason why he couldn't pay that before is the same reason why he can't pay it now. And I agree with everything you said. All those things are absolutely true. But we are asking for a reduction based on his financial hardship. He does not make enough money to pay the city $9,000. And if the city reduces his lien to that, that is generous. But it will still have the same problem. He still works minimum wage, or very close to it, at Sewell Hardware, where he's worked for 3 decades. He lives in that home. That is his homestead. No one else owns it. He complied it, but he's had terrible health problems, which is also his hardship. And so.
So what are you asking for?
I'm asking for $3,000 for everything with 6 months to pay. And at that point, I understand. The family, if that would intervene in behalf of that, if it was worse than that. But right now, it's his problem, and I'm trying to help him. I'm certainly not charging my own cousin. We're trying to do everything we can to get him back in his own house.
The city's position remains the same, Special Magistrate.
Would time help?
I still think he's still at the job level where his income is right there covering most of what he does. He can afford $3,000, but at this point where he lives, in order to pay and live and eat and insure his car and those things, he is very, very close. That's why I say this is the hardship that I'm trying to present to you. And I'm not disagreeing that it's not generous. It is. But at this point, this is what I'm asking for because he cannot do otherwise. And had I known about this, I would have gotten involved a lot sooner. But he didn't want to burden his family at that point. I would have been involved a long time ago. I'm familiar with code enforcement. I would have tried to help. But he didn't involve us then.
May I inquire if he's able to pay $3,000 in 6 months? Can he pay the $9,000 in 18 months?
I don't think that he could because at that point, if he's paying at that much money, he literally has nothing else to live on. And he's got financial hardships with his health that also requires a lot of unseen expenses and medications.
Oh, I'm just going by your calculation and formula. If he's able to pay $3,000 in 6 months, then we would extend that $9,000 for 18 months.
I appreciate the math. I'm just telling you that that's also not possible. Because right now, that would mean that almost every single dime he has to live on would go to the city of West Palm Beach for a code violation against his own home that he complied. And I agree that it's accurate. I'm just saying what he can do and what he can't, and I'm asking to show mitigation just based on that. Not a defense, just mitigation. That
Well, I mean, hardship's legit, though. In fairness, the city has come down
To 10%.
Yeah.
Well, close to 10% of the total
Yeah,
amount.
I mean, they
If the
basically
total is-
cut.
If the city came down 10%, I mean, that's numbers. I'm telling you, though, that he is a minimum wage worker at Sewell Hardware, where he's been for three decades. He's lived at the same house for 3 decades. He doesn't have it. And I appreciate 10%, 15%, things like that, but I'm trying to explain, he cannot pay those numbers. And I'm not, he is trying to do everything he can to do this, but at this
All
point.
right, this is what I'll do. I'll do in case CE 160300291, I'll reduce that to $2,000 payable within 12 months. On case CE 070400338, I'll reduce that to $1,000 payable within 12 months. And on case 24, which is CE 060400590, I'll reduce that to $2,000 payable within 12 months.
How much is that?
$5,000.
We appreciate that. Thank you very much.
Good luck, sir.
Missed it.
We got one more?
One more.
One more.
Case number 22, CE 211-10107, case address 710 10th Street.
Good morning, barely, but still morning. Rebecca Zissel here on behalf of the property owner.
Hold on one sec. Let me let the city introduce the case, and then I'll let you.
Sorry.
No worries.
Apologies.
John Frosca for 710 10th Street, CE 210107 for, we had a meeting before it started, and we could not negotiate the amount, and the attorney recommended that she speak to her client, and she wants to continue this case to have her client show up at the hearing, and the city is agreeable for that, to continue the case.
Ma'am, you want to make your appearance?
Yes, sorry. Rebecca Zissel here on behalf of the property owner. I agree with what the city has said. We're hoping, we thought we could come to an agreement. Given the numbers I was given from my client, we were not able to, and I would prefer to have him here. There's a number of things he is more personally familiar with, because a lot of this dates back to 2021 and 2022 before I was involved, and since it would be under oath, I would like to have him here, so apologies, but if possible, can we get a continuance?
That's reasonable. When do we want to reset this for?
July 2nd, I believe, is the next, or would we prefer to hear it in front of?
Council, does that work for you, July 2nd?
I can check I can check with my client. Would it be possible if that doesn't work to change it to the next available date, or is July, that's a Wednesday? Is it a Wednesday also?
It's always a Wednesday.
It's always a Wednesday, yeah, that's what I thought. That should be fine.
All right, you know what we'll do? We'll reset it for July 2nd. If that doesn't work, then you have my permission to set it to the next one. All right?
Yes, sir.
Appreciate it. Thank you. Thank you both. Thank you.
Thank you.
Seeing no further business before us, we are adjourned.